In the realm of criminal law, jurisdiction is not just a fancy legal term. It's the very foundation upon which a government's power to punish wrongdoers rests. Imagine a crime as a house of cards. Jurisdiction is the table upon which it stands. Without it, the entire structure collapses. Simply put, jurisdiction is the authority of a court to hear a case and render a judgment. In the United States, we have a dual system of government, with both federal and state governments possessing the power to enact and enforce criminal laws. This division of power naturally leads to questions about which sovereign has the authority to prosecute a particular crime. This is where the concept of criminal jurisdiction becomes crucial. It acts as a dividing line, determining whether a crime falls under the purview of federal law, state law, or both. The consequences of misunderstanding jurisdiction can be severe. A prosecutor might bring charges in the wrong court, leading to a dismissal of the case even if the defendant is demonstrably guilty. Conversely, a defendant might mistakenly believe they are outside the reach of the law, only to find themselves subject to prosecution in a jurisdiction they didn't even know applied to them. This is why it's crucial to understand the fundamental principles of criminal jurisdiction. It's about ensuring fairness, upholding the rule of law, and ultimately, protecting the rights of both the accused and the public at large. In the following sections, we'll delve deeper into the intricacies of federal and state criminal jurisdiction, examining the scope of each and the factors that determine which sovereign holds the power to prosecute. The United States federal government derives its power to enact and enforce criminal laws from the Constitution. However, unlike states, which enjoy broad police powers, the federal government's criminal jurisdiction is limited and enumerated. This means that it can only enact and enforce laws related to specific subjects outlined in the Constitution. One clear area of federal criminal jurisdiction is over federally owned territories. Think of national parks, military bases, and federal buildings. Crimes committed within these territories fall squarely under the jurisdiction of federal law. For example, vandalizing a national monument or assaulting a park ranger would be prosecuted in federal court. Federal jurisdiction also extends to conduct that occurs within states but has a significant impact on interstate commerce or national interests. This includes crimes such as drug trafficking, counterfeiting, and cybercrime. These offenses often cross state lines, making it difficult for any single state to effectively investigate and prosecute them. The federal government, with its broader reach and resources, is better equipped to handle such cases. Furthermore, the United States asserts criminal jurisdiction over its citizens and nationals, even when they commit crimes abroad. This principle, known as nationality jurisdiction, allows the U.S. government to prosecute its citizens for crimes like terrorism, drug trafficking, and child exploitation, even if the offenses occur on foreign soil. Finally, the federal government possesses maritime jurisdiction, which grants it the authority to prosecute crimes committed on the high seas or navigable waters within the United States. This includes crimes committed on ships flying the U.S. flag, as well as offenses related to piracy, maritime terrorism, and drug smuggling in international waters. While the federal government's criminal jurisdiction is limited and defined by the Constitution, state criminal jurisdiction is much broader and derives from the 10th Amendment. This amendment reserves to the states all powers not specifically delegated to the federal government, including the vast and essential police power. This power allows states to enact and enforce laws that protect the health, safety, morals, and general welfare of their citizens. This means states have the primary responsibility for prosecuting most crimes that occur within their borders. This includes offenses like murder, assault, theft, and DUI, to name just a few. In essence, if a crime isn't specifically designated as a federal offense, it likely falls under the purview of state law. Unlike the federal government, which has limited jurisdiction, states have what is known as general jurisdiction. This means that their courts can hear a wide range of cases, both civil and criminal, unless a particular case is specifically excluded by law. This broad jurisdiction reflects the state's role as the primary guarantors of peace and order within their territories. However, just because a crime occurs within a state's borders doesn't automatically mean the state has sole jurisdiction. As we've seen, some crimes, like drug trafficking or counterfeiting, can have interstate implications, triggering concurrent jurisdiction. This means that both the federal government and the state where the crime occurred have the authority to prosecute the offender. In such cases, the decision of which sovereign will bring charges often depends on factors like the severity of the offense, the resources available to each jurisdiction, and the potential penalties involved. Section 4. The importance of where it happened. Situs of the crime. The concept of situs of the crime, meaning the place where the crime occurred, is crucial for determining jurisdiction, especially in our geographically defined legal system. Traditionally, courts relied heavily on this principle to establish jurisdiction, particularly in cases where the acts constituting the crime took place in multiple jurisdictions. Imagine someone firing a gun across state lines, with the bullet striking and killing a victim in a different state. This scenario presents a jurisdictional puzzle. Which state has the authority to prosecute the shooter for homicide? The answer lies in determining the situs of the crime, which in homicide cases is typically where the victim died. However, the increasing complexity of criminal activity, particularly in our interconnected world, has challenged the traditional reliance on situs as the sole determinant of jurisdiction. For instance, consider cybercrime, where a perpetrator in one state can hack into a computer system in another state, causing financial damage or stealing sensitive information. In such cases, pinpointing a single situs for the crime becomes incredibly difficult, if not impossible. Section 5. Modern expansions of state jurisdiction. Fortunately, legal systems have adapted to address the challenges posed by modern criminal activity that transcends geographical boundaries. States can now assert jurisdiction based on a broader range of factors, moving beyond the strict confines of where the crime physically occurred. One such basis is the effects test, which allows a state to assert jurisdiction if the effects of a crime are felt within its borders, even if the conduct itself occurred elsewhere. For example, if someone commits fraud in one state but the victim resides in another state and suffers financial harm there, the victim's state could assert jurisdiction based on the effects test. Another basis is the objective territorial principle, which grants a state jurisdiction over crimes that, while initiated outside its borders, are ultimately completed or have their intended effects within its territory. For instance, if someone sends a threatening letter from one state to a victim in another state, the state where the victim received the letter could claim jurisdiction based on this principle. These expanded jurisdictional bases reflect the reality of modern crime, where actions taken in one location can have far-reaching consequences in others. They provide states with the necessary tools to prosecute offenders whose conduct, while perhaps physically distant, nonetheless harms their residents and interests. Section 6. Conclusion. Navigating the labyrinth of jurisdiction. Understanding the complexities of federal and state criminal jurisdiction is vital for ensuring that justice is served and the rule of law is upheld. It's a system of shared and sometimes overlapping authority, requiring careful consideration of the nature of the offense, the location of the criminal acts, and the potential impact on various jurisdictions. As we've explored, the federal government's criminal jurisdiction, while limited, plays a crucial role in addressing crimes that transcend state boundaries or threaten national interests. States, with their broad police powers, retain primary responsibility for maintaining peace and order within their territories. However, the traditional reliance on the situs of the crime to determine jurisdiction has evolved in response to the complexities of modern criminal activity. New jurisdictional bases, like the effects test and the objective territorial principle, allow states to reach beyond their physical borders to prosecute crimes that harm their residents or interests, even if the conduct originated elsewhere. Navigating this labyrinth of jurisdiction requires a nuanced understanding of the law and a careful analysis of the specific facts of each case. By appreciating the distinct roles of federal and state governments in enforcing criminal laws and recognizing the evolving nature of criminal jurisdiction, we can strive for a legal system that effectively combats crime while respecting the principles of fairness and due process.